loans are not assets. I keep on hearing this. We all know that they're not assets. Mr. Kilpatrick made disclosure of what Your Honor asked him to disclose. Originally, it was a question of income, gifts, and benefits. And that's what he disclosed because that's what Your Honor said he should disclose, and he's obeyed that order. There is one other point that I need to bring out. As a result of the proceedings last week, Mr. Kilpatrick's bank, the Bank of America, received a number of calls from people in the 313 area code, some 2 or 3 I believe is the number, in which they had gotten some materials which were part of bank accounts that he had. And because of that, the Security Department of Bank of America has now closed down those accounts, and he can't get access to ATM machines or credit cards or anything like that because they are in the process of trying to discover who it was who sought to invade that account to try to get credit cards in what they purport to be their name. And so that's undergoing. The reason I bring this out, Your Honor, is last time we had this television here, which is unnecessary. The only reason that we have this television is so that people who don't need to make decisions in this case can see whatever it is that the prosecutor wants to put out. Now, Your Honor's already got all that information because that comes to Your Honor. There's no jury here, so the decision maker doesn't have to make any decision other than you, because you are the sole decision maker in this case. You've got all the material. This TV is only going to be used, as it already has been apparently, by people outside of this courtroom for illicit purposes. To disclose Mr. Kilpatrick's information in the normal course, that's sent to the probation department, and that information is normally sealed and is not made public. And now we have a situation which, unfortunately, it is being made public. I'd asked for a protective order, which Your Honor granted. Now we have a situation where it's being put out there, and apparently people who are attempting to use that information illicitly and engage in criminal activity are doing so based upon what's being broadcast out here through this TV. I would ask, Your Honor, since there is no purpose to that TV being put out there and these people getting all that information, that Your Honor instruct the prosecutor turn off the TV, because everything that the prosecutor is going to put up there, without exception, is something which is a document which you've got already, or which will be given to you as part of any proffer of evidence in this case. You don't need to see it on TV when you can have it right in front of you in paper. And because of the damage that's already been done, I ask that that be turned off and that we not have any further indications of information in there that could be used by members of the public to engage in criminal activity.
Mr. Ringus, response to that last?
This is a public hearing. The defendant is the former mayor of the city of Detroit. Clearly, by looking around, there's a great deal of interest in what happens in this courtroom, and in order to have full transparency, I think that the public has a right to know. This court, there's things that we can show, that we may want to show the witness. I don't think that that's a proper objection to say that we can't show it on a monitor. The court has entered an order, and we've respectfully gone through that order and redacted information that the court has asked us to redact. We have respected Mr. Kilpatrick's privacy in that regard. We have not given out to the media any of his bank account numbers. If certain individuals have discovered that, that's nothing more than individuals going on the internet and stealing other people's information. There's nothing that we've done in this hearing to encourage that. I don't know if that in fact has happened. I'm kind of suspicious that all of a sudden now his accounts are frozen and he can't get information, and it's really rather interesting that he in fact, just when we're in the midst of this hearing on October 15th, he and his wife closed down their joint checking account, and now it's zero. So it's rather interesting, the shell game that the defendant continues to play is going on here. We have a representation made by his lawyer that this is for security purposes, therefore we can't gain any additional information in these accounts. Isn't that very interesting when we're in the middle of this hearing and trying to put and shift the burden and be offensive to say that it's for security reasons? And excuse me if I'm being skeptical in that regard, but based on history here, I don't know that that's accurate.
All right.
But there's nothing that we're gonna do in this courtroom that's gonna jeopardize his accounts.
Mr. Schwartz, you've had 2 bites of the apple. Ms. Soria's had 2 bites of the apple. I need to continue this argument. All right, the court's going to make the following ruling. Excuse me, a little bit of a cold. The court does feel that this is a relevant hearing. This is a restitution hearing. As far as whether, and we are going to continue this hearing, there was never an objection before at the last hearing. You never raised an objection, Mr. Schwartz. You never said anything till today. The second of all, and more importantly, when the information that the prosecutors have was based on subpoenas on bank or banks that the defendant has bank accounts with. And there was never an objection from you as to those subpoenas, nor from the bank. And that's why those subpoenas were honored, and the bank complied, and you raised no objection until today about that. So I think that for you to stand up now and say that there's something that's inappropriate about what the prosecutor's asking, you have all the information that she's asking questions from. It's not a surprise to you or your client. All the information is based on documents that you have or bank accounts that he has.
Your Honor, the subpoenas were not, I was not given advance notice of the subpoenas until after the material was already received. One cannot object to something when it would be moot at that point, because the prosecutor, who should have given me a copy of the subpoenas in advance, didn't do so. And as a result, what the bank did, I can't speak for the bank, obviously. But in terms of the subpoenas, they subpoenaed things in violation of the rules. And now they're coming forth and saying, well, they don't know. All they've got to do is call up Bank of America, their security department, and they can find out from Bank of America what's going on. They don't have to be speculating. They don't have to be surprised or whatever it is that they claim to be. All they got to do is call the bank.
All right, anyway, I'm going to deny your motion to stop the hearing, if that's what you're asking me to do. I'm not going to do that. I think it's highly relevant. As far as the documents go, obviously the court is concerned, Ms. Sorinas, that there be no information on that television, i.e. account numbers, social security numbers, anything like that. And you know the rules, and I've already signed a protective order. I will only allow you to put something on that screen that, in my opinion, or hopefully you will not put anything up there that will disrespect the defendant's right to privacy on those issues, because we do not want him using anyone using that information for any illicit purposes. And obviously, I hope and I would think that you're very sensitive to that issue.
We are, Your Honor. We've gone, I mean, there could be, and I'm going to ask Tommy Napso sitting here. He's my technical advisor, and hopefully anything that comes up on the screen, we've already had information. Account numbers redacted. We've had addresses redacted from the documents that we'll be displaying. And I'm going to ask Mr. Napso to, again, before he pulls out a document and shows it, to look at it again and make sure that there's nothing that is confidential that would be displayed.
Okay, then what we'll do then is, Mr. Kilpatrick, if you could resume the stand.